Thank you for tuning in to the Brock Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent alert from Brock Eichler titled, Governor Murphy Signs Medical Debt Relief Act. On July 22, 2024, Governor Phil Murphy signed the Louisa Carman Medical Debt Relief Act into law. Effective July 22, 2024, the Act prohibits medical creditors and medical debt collectors from reporting any medical debt to a consumer reporting agency, such as Experian or TransUnion, for healthcare services performed on or after the effective date. Medical creditor is defined in the Act as any person or entity that provides healthcare services and to whom a patient owes money for healthcare services. This would include virtually all healthcare providers, including physician practices, ambulatory surgical centers, and hospitals. Medical debt is defined as debt arising from the receipt of healthcare services. Effective July 22, 2025, the Act will further prohibit medical creditors and medical debt collectors from 1. Charging an interest rate on medical debt of more than 3% per annum. 2. Garnishing the wages of a patient with annual income less than 600% of the federal poverty level. And 3. Beginning collection actions until 120 days after the first bill for medical debt was sent and the patient has been offered a reasonable payment plan. A reasonable payment plan is defined as a structured repayment arrangement that satisfies the following criteria. 1. Monthly payment amounts set at a level that the patient can reasonably afford. 2. A duration that allows the patient to repay the debt in full within a reasonable time frame. 3. The terms of the payment plan are documented in a written agreement provided to the patient. 4. Provisions for adjusting the payment amounts and duration in response to changes in the patient's financial circumstances. 5. A grace period of at least 60 days for late payments. And 6. The plan cannot charge an interest rate of more than 3% per annum. Any communication made by a medical creditor or medical debt collector to a patient in the course of trying to collect a medical debt must include a statement that the medical creditor or medical debt collector has not reported the debt to a consumer reporting agency and that any debt reported is void. Providers should be aware of the Act's requirements when assessing how to collect patient debt and when considering who to sell any unpaid receivables to, or whether to sell the debt at all. Upon your request, we will forward you an official copy of the Act. For additional information, contact John D. Fanburg, Esquire, Managing Member and Chair, Healthcare Practice, Co-Chair Cannabis Industry at jfanburg at brockeichler.com or 973-403-3107. Edward Hiltzenrath, Esquire, Member, Healthcare Practice at ehiltzenrath at brockeichler.com or 973-403-3114. Andrew Cooter, Esquire Associate, Healthcare Practice at acooter at brockeichler.com or 973-403-3141. This is intended to provide general information, not legal advice. Please contact the authors if you need specific advice. Brock Eichler, LLC is a full-service law firm based in Roseland, New Jersey, with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax and cannabis law.